Breaking news, Atiku's camp urges Tinubu to resign over his Chicago academic record. So guys, we all know that we've been on this topic for a while, and tomorrow is the D-Day. The judge in the US is going to rule over this case on whether the Chicago State University is going to release this record or not. Tomorrow is that final day. But you can see Atiku is so smart for him to start calling Tinubu to resign on time, even before the judge rules, his final verdict tomorrow. Atiku is saying, Tinubu, you must leave office because we are not sure of the kind of certificate you submitted to INEC, and you submitted it under oath. Can you imagine? Tinubu has said that the Chicago State University shouldn't release his academic record to avoid irreparable damage.
Judge Jeffrey Gilbert of the United States District Court for the Northern District of Illinois stated that President Bola Tinubu weakened his education privacy rights when he submitted a contentious certificate to run for office in 2022. The judge said the need to confirm the genuineness or otherwise of the certificate Tinubu submitted to the Independent National Electoral Commission, INEC, outweighs Tinubu's personal concerns over its consequences. Opposition leader Atiku Abubakar had sought a subpoena to obtain Bola Tinubu's academic records following several inconsistencies in the submissions Tinubu certified under oath to INEC. But President Bola Tinubu had desperately fought to have his records blocked and inaccessible to Atiku Abubakar. Tinubu pleaded that granting his opponent access to his records would infringe on his privacy rights under the Family Educational and Privacy Rights Act, FERPA, a U.S. law that protects students' academic records. But Judge Gilbert, in his ruling on September 19, said the opposition candidate's election petition, in which the records he sought would be used, far outweighed Mr. Tinubu's privacy interest because he exposed his records to public scrutiny by submitting a controversial diploma to INEC, knowing the political stakes of other contenders. The judge said the Family Educational and Privacy Rights Act permitted records disclosure if it is necessary to comply with a lawfully issued subpoena or judicial order. Here, the court finds that the applicant's interest in obtaining intervener's record from Chicago State University outweighs intervener's privacy rights because intervener put his diploma at issue by submitting to INEC. Judge Gilbert said in his ruling issued late Tuesday over the case filed on August 2. He said Atiku Abubakar's petition was far too crucial to ignore. Meanwhile, rattled by the United States Magistrate Court's order directing Chicago State University to release his academic records to the People's Democratic Party, PDP presidential candidate Abubakar Atiku, President Bola Tinubu on Thursday rushed to file an emergency application with the district court to stall the order's implementation. The jittery President Tinubu contended that a magistrate should only report and recommend to the district judge in such matters. Tinubu further argued that the magistrate court had issued what seemed to be a final order on September 19, demanding immediate compliance starting on September 21. He requested the court to delay effect of the magistrate's order until September 25, 2023, to fully consider its scope and its application of the law to the facts presented. If Chicago State University complies with the magistrate's order prior to this court having an opportunity to review the order, intervener will suffer prejudice because the information will have been disclosed and effective relief will be impossible. At an emergency hearing on Thursday, a judge of the District Court of Northern Illinois, Eastern Division, Nancy Maldonado, agreed to delay an order requiring Chicago State University to provide the academic documents of President Tinubu. The order brings a reprieve to the Chicago State University and Tinubu in their first efforts to convince the court against ordering the release of the requested documents. Ms. Maldonado ordered the lawyers on both sides to file additional arguments by next Thursday, September 28. Mindful of legal deadlines in the Nigerian Supreme Court, Ms. Maldonado said she would rule as quickly as possible after that. "I'll have a busy weekend," she said. The former vice president requested 4 documents from Chicago State University. 1. An example of a Chicago State University diploma issued to President Tinubu in 1979. 2. Mr. Tinubu's diploma issued in 1979. 3. Any example of a Chicago State University diploma that contains the same font, seal, signatures, and wordings as contained in Exhibit C to the first Leo Declaration, which purports to be a CSU diploma issued to Mr. Tinubu on or about June 22, 1979. 4. Chicago State University documents certified and produced by Jamar Orr, an Associate General Counsel at CSU at the time. The PDP presidential candidate in the 2023 general election, Atiku Abubakar, had on Tuesday in Nigeria filed an appeal to the Supreme Court seeking to overturn the September 6 judgment of the Justice Haruna Samani-led Election Petitions Court that affirmed Tinubu's victory in the February exercise. The subpoena is expected to help Atiku obtain a certified clarification under which Bola Tinubu was admitted into Chicago State University and the diploma he submitted to INEC, which was purportedly issued in 1979 and signed by Elnora Daniel. But Ms. Daniel only arrived at the Chicago State University in 1998 from Hampton University, 19 years after Tinubu was said to have graduated. The People's Democratic Party, however, views Tinubu's motion as a delay tactic to stall the release of academic records before the Supreme Court begins hearing Atiku's appeal against the September 6 judgment of the Presidential Election Petition Court. It should be now obvious, even to the blind, that Tinubu is hiding something in his records at the Chicago State University and even elsewhere. According to the PDP, it is just a matter of time before Nigerians begin to see the true position of Atiku on the records of Tinubu at the Chicago State University.
So guys, let me allow you listen to what Dr. Ted got to say, because we are wondering, why should the US be delaying on this case? Why have they not released their final verdict even before now? Because Atiku needs this document to pursue his appeal at the Supreme Court.
You know, one of the things the previous judge granted, one of the prayers the previous judge granted Atiku was to interview Chicago State staff under oath, because Atiku want to compel them to explain to him the person who signed a certificate in 1979, whereas that same person was employed 20 years after. By the time the Chicago State University management staff are interviewed under oath, it will expose the rot that is happening in that university. I have a lot of friends in UK, in US, that have told me that that university is notorious for certificate racketeering. And you know, they said birds of the same feather flock together. That university is notorious for certificate racketeering. That is why someone who is employed today can afford to sign a certificate that was issued 20 years ago. And Atiku is trying to do damage to that university. That's why no staff of that university want to say anything under oath, because it could cost them their job, because it could land them in jail, because that school can be exposed beyond irreparable fashion. That's number one. Number two, when you talk about national security, if you have something on somebody and that person wants it protected at all costs, the person will do your bidding. I mean, if you watch movies, you will see people whom, because of a certain thing, a certain skeleton in their cupboard, people who have that, it's like blackmail. Let's just use it that way. If our president happens to be blackmailed by any other country because of information they have about him, that may be an information that if that thing were to be made public, he should not be a president. Don't you see that he's going to be at the beck and call of that person who is pulling the string? So that is a challenge. And like he said, in this era of neo-colonialism, now, We don't know. Look at countries like Cameroon. Look at countries like Senegal. We don't know what the colonial masters have on their leaders. That is why they can afford to do things against their people, and the colonial masters are just okay. That tells you that there is a string, those people, there's a string a country like France is pulling, controlling some president like in Cameroon, like in Senegal, like Ivory Coast, and all whatnot. So what the man, I think, is trying to say here is it won't be nice for Nigeria to be exposed in the same fashion and in the same manner. So that's what I see there, and that's my thinking so far. All right. So the next thing I think we need to touch now is this same week we heard about the governorship election tribunal that occurred in judgment that occurred in Kano State and then occurred in Enugu State, and we've heard how the judgments came out. The one of Kano State is already causing a whole lot of riots currently in Kano State, and a lot of people have been commenting and lamenting and trying to say that the judges were bought. Others are saying that the judges of the governorship election petitions tribunal in Kano State was harassed by APC to give the kind of judgment that they gave and all whatnot. But there is someone who did an analysis, something I want, if it is possible for us to show here. Just that slide by Wanundubisi Ekekwe. He gave a summary that I had also thought of, but it would be nice for us to have it there for those who could read while I point it out. For instance, now there is a pattern that I have seen here. When APC want to deal a blow to you, there is a method they use, and to a large extent, it's like the judiciary always back them. You remember what happened in Imo State? How all of a sudden, from one ward, there was a massive vote that the current governor of Imo State, brought to the Supreme Court and said, INEC did not include this vote because they didn't include it. They deprived me of the opportunity. And by the time the whole vote was counted, it made him get more votes than PDP. And that is how Ihedioha was kicked out of power. And Hope Uzodinma is now the governor. Now, look at what happened in Kano. My people, please let us think about this thing. As much as 165,663 votes was deducted from NNPP. The court did not say that when they deducted 165,663 votes that either not stamped, signed, or dated, they did not tell us anyone that was deducted from APC, anyone that they deducted from any other party, APC, PDP, SDP, and even Labour Party. Remember that PDP participated in the Kano State election. Remember that SDP participated in the Kano State election. Remember that Labour Party participated in the Kano State election. Now, is it possible, my fellow Nigerians, that out of that 165,000 plus, that it was only NNPP that was voted? Because the court did not say that when they deducted that invalid 165,000 plus votes, they did not even mention that the vote of APC dropped by 1 vote. They did not mention that the vote of PDP dropped by 1 vote. They did not mention that the vote of Labour Party or SDP dropped by 1 vote. If you read the judgment, it simply says, even the APC lawyer simply said it, that 165,000 plus votes was brought to the court that was not stamped, that was not dated or signed, and that vote was deducted from NNPP. So the question Nigerians we need to ask ourselves is this: is it possible that as big as much as 165,000 votes, which were invalid ballot papers, became invalid, held by INEC, and they voted only one party? Think about that. It is important that Nigerians think about that. APC did it in Imo State and they got away with it. And that is why they are trying it again in Kano State. And that is why we are trying to say that when we allow crimes like this to be sustained, it emboldens the perpetrators to do it again and do it again and do it again. We may not have time to even talk more of what happened in Enugu State. When we have seen that judges after judges, even in the so-called election petition tribunals, have been disqualifying people for certificate forgery. But Enugu State Tribunal decided that this time around, they will not disqualify anybody for NYSC certificate forgery because according to their word, it is not a qualification to become a governor. But the court had firmly said, I'm waiting, Nigerians, I am waiting to see what the appeal court will say, because this appeal court have already held it before, that whether the certificate qualifies you or it does not qualify you, provided it is forged, it will disqualify you. I'm saying this today so that we Nigerians, we can keep our ears open and keep our eyes open and watch what will come from the appeal court. If they endorse what this tribunal has said, then Nigeria is completely finished. Because it means that these judges and these courts can be doing cherry picking. When they like you, they invoke this law. If they don't like you, they drop it. Because Supreme Court, Appeal Court, times without number, have nullified people's qualification simply because the certificate they tendered was not issued. This is a case that even the Director General of NYSC said before the whole world that the governor came to him and that they told him, this certificate you're parading, we did not issue it to you. A law firm extracted a certified true copy from INEC, what was submitted, and these judges upheld the fact that that certificate does not qualify him. That as long as school certification, school cert is what qualifies him, that this person is overqualified, having gotten masters, having gotten honorary doctorate degree, and gotten university degree, and gotten a law degree. But the person submitted a certificate that is forged. So this is the first tribunal we are hearing that can now discountenance the impact of forgery, because it is not a the certificate that was forged is not a qualifying certificate. Whereas the appellate court that is above that level of court have held times without number that it does not matter whether the certificate qualifies you or not. As long as it is forged, it can terminate your opportunities. So this is like an alarm we are raising. Let's keep our ears open and keep our eyes open and see what the appeal court will do. If the appeal court sustains this judgment, then we can say our judiciary is gone. If they nullifies it, then we can say maybe this time around the presidential is more important to them, and they have done what they have done with the presidential. All right, but you can see what happened in Enugu State and Kano State. It tells you that our judiciary so far is like cherry picking kind of people. You took a vote They say they brought it to you, INEC. Now they were able to compel INEC. Now that's another thing. This judiciary, these judges compelled INEC to submit this. But our appeal court, which held the Presidential Election Petitions Tribunal, could not compel INEC to produce what they used to conduct election. That is it. And secondly, that polling unit they are condemning in Kano State, that polling unit, is it on the IREV? If we go to the IREV, can we see that it is only NNPP that was voted there? That is another thing Nigerians have not pointed out, because these judges completely boycotted everything that had to do with Beavers and IREV. Because if they have recognized IREV, then Nigerians will see that polling unit and know whether indeed 165,000 polling units, 165,000 ballot papers, which is polling units, because there is one polling unit for one result sheet. Whether there is 165,000 there where only ANPP was voted.